New York State Court of Appeals is obliged to throw it out on constitutional grounds. So People of the State of New York by Letitia James, mortgage fraud, Attorney General of the State of New York versus Donald Trump. And I think I have to get to page 115. Remedies. These are the fines. Yep, this is where I want it to be. So let's get to let me get my red pen. Let's see. 1 second. So Judge Erdogan, when they say Supreme Court, that means the trial court. Remember, New York State does this in a weird way. New York State's trial courts are what they call their Supreme Courts, not like in a normal state where the Supreme Court is the highest court in the state. This is effectively the lowest court in the state. In its trial decision, the Supreme Court imposed sweeping equitable relief on the defendants, meaning Donald Trump. The court awarded disgorgement, meaning fines, against Trump in a combined amount of $464 million. 363 or 364 of what the court called ill-gotten gains, and 101 million in prejudgment interest. The lion's share of disgorgement was awarded against President Trump, the Donald J. Trump Revocable Trust, and various other Trump entities. His sons, Donald Trump Jr. and Eric Trump, were ordered to pay $4 million each, and a business advisor was ordered to pay $1 million each. Additionally, because the Supreme Court, the trial court, found the defendants were likely to commit future misconduct. So this is like, what was that Tom Cruise movie where they have future crimes? These are future crimes. Maybe one of you can mention it. I'm sure somebody in the comments will remember. Because the trial court, Judge Erdogan, found defendants were likely to commit future misconduct, Minority Report. Nailed it. Thank you, man. It issued broad injunctive relief. So equitable relief is the money. Injunctive relief is like prohibiting you from doing things. It prohibited Trump and corporate defendants from applying for loans from any financial institution chartered or registered with New York State. It barred Trump, his advisors, from serving as corporate officers in New York for 3 years, barred Trump's sons from doing so for 2 years, barred the business advisors from serving in a financial management role in New York, extended the independent monitor's term for 3 years, and enhanced her authority. Of course, it's a her. So Judge Erdogan put a Karen in charge of Trump's business operations. Why would you want to do business in New York State if they can do that to you? Required the Trump organization to retain an independent director of compliance. Defendants, meaning Trump, of course, challenged the massive fines ordered by Judge Erdogan. I'm going to get to the substance here. The focus of these fines is on separating the fraudster from the money that he gained from the fraud. You know, the fraud where nobody was defrauded. Because the Attorney General in the lawsuit is vindicating a public purpose, defendants' ill-gotten gains would revert to the New York State Treasury. The defendants, Trump first argues that the fines is not a remedy afforded by this consumer protection law, where no consumer was harmed here. So they say fines would be allowed. Defendants say the fines are not allowed by the statute. This appellate court finds the fines would be allowed. Defendants argue that the trial court's fines violates the excessive fines clause of the New York State and federal constitutions. And this is where they zero out the fines on this basis. The U.S. Constitution 8th Amendment excessive fines clause laid mostly dormant for all of American history until 1993, when the United States Supreme Court handed down a couple of cases, ruled for the first time the Constitution placed limits on punitive civil fines, holding that fines are subject to being cruel and unusual punishment, excessive fines. In another case, the court held that criminal forfeitures constitute fines within the meanings of the excessive fines clause, emphasized that courts must analyze excessive fines clause challenges separately from Eighth Amendment cruel and unusual punishment clause challenges. In each case, the Supreme Court of the United States left the lower courts the task of formulating a test for excessiveness. This law in this area is unsettled. Initially, we, the Appellate Division, the Court of Appeals in New York, must determine if the fines in this case constitute fines within the context of the excessive fines clause. We look at several factors. The bottom line is they do. They decide it does. Accordingly, the fines here constitute fines. All right, took us a long time to get here, but obviously. The remaining question is whether the fines levied against Trump in this case are excessive and barred by the Eighth Amendment. We believe that it is. Violates the Eighth Amendment of the Constitution. A fine is excessive when it is grossly disproportionate to the gravity of the defendant's offense. Remember, here the fines are in excess of $500 million. Trump's attempt to deny the gravity of their actions with blithe claims that none of the county parties were harmed ignores a core reality. A bank making a loan seeks not only repayment, but also compensation for the possibility of default. Every bank here, by the way, said they did their own valuations, did not rely on Trump's, relied on their own valuations for their risk assessment. So this is all fabrication by the courts trying to get Trump. However, while harm certainly occurred, this court summarily concludes that's not what any of the lenders said. Nobody said they were harmed in this case. Not one party, not one supposed victim claimed harm. Nobody ever claimed harm in this case, except Letitia James on behalf of the state of New York, which obviously was not a party to these transactions. But this court decides while harm certainly occurred, it was not the cataclysmic harm that justifies nearly $500 million award to the state. It's a virtue of the statute, the Consumer Protection Statute, when not one consumer complained that the Attorney General may act, as she did in this case, before a potential catastrophe occurs to deter fraudulent business behavior by defendants specifically and to police market behavior generally. However, having achieved these goals, the state is not entitled to compound its victory with a massive punitive fine. Additionally, a fine cannot be proportionate to the offense unless it is reasonably calculated to encompass only the actual proceeds that the defendants realized from their fraud. To obtain disgorgement, the Attorney General bears the initial burden of establishing a reasonable approximation of profits connected to defendants' violations. Remember, the fraud here is supposed to be property valuations. Here's an example of where this court, the court of Judge Erdogan, let me find my notes here. This is one of the examples of how Judge Erdogan determined fraud here. Remember, there was no jury. He granted summary judgment to the state of New York for part of the case, and then he was the jury. It was a bench trial. So he was the finder of fact for the trial itself, this one judge. And this one judge decided one of his key indicators of fraud involved Trump's property of Mar-a-Lago. We've all heard about Mar-a-Lago, right? Trump estimated the value of Mar-a-Lago at $350 to $750 million. The judge said, no, it's only worth 18 to 30 million. 18 to 30 million, according to the judge. Mar-a-Lago every year generates $50 million in revenue. $50 million. Only someone who's a complete ignoramus could believe that any asset that generates $50 million a year in revenue is worth only $30 million. Let me ask you, if I had a machine that printed $50 million every year, would you pay $30 million for that machine? Of course. Any valuation that someone would purchase or loan against, the value of the asset that generates revenue on an annual basis is a multiple of each year's revenue generation. Say you were going to buy Mar-a-Lago. You wouldn't, and it produced 50 million a year, you wouldn't just be expected to pay 50 million for it. Everyone knows you're going to have it more than 1 year. You pay a multiple. Now, what the multiple is for different businesses varies. But I think it would be perfectly reasonable to say, all right, it makes 50 million a year. Let's have the multiple be 7. So if you want to buy Mar-a-Lago, you have to pay us 7 times the annual revenue. So at 7 years, you break even. After that, you're making profit. I think that would be perfectly reasonable. But this judge says, no, not only is Mar-a-Lago not worth 350 million, even though it generates 50 million a year, it's not even worth 50 million. It's not even worth a single year's revenue. It's only worth 18 to 30 million. Absolutely insane. And this Court of Appeals accepts that this was fraud on the part of Trump. If there's fraud here, the fraud is on the part of the trial judge, Erdogan. But nevertheless, this court, I didn't mean to make myself quite that small. This court, how many real estate transactions do you think Judge Erdogan has been involved in as a participant? It's insane. Absolutely insane. And Trump brought in scores of experts to testify in court, and Erdogan just waved away all their testimony. You know how many real estate experts Letitia James, Attorney General James, brought in to testify for her side of the case? None. Not one. It was her and the judge making these calls. So the appellate court says, well, you know, Letitia James, she has the initial burden to show that defendants are obliged to demonstrate that the disgorgement figure was not a reasonable approximation. She did not carry her burden. Indeed, the calculation of the fines in this case was far from a reasonable approximation. The profits from the sale of one license, the fines were completely disconnected from economic reality, is what the Court of Appeal says here. Let's see if there's any details here. I don't want to get into the nitty-gritty. For the foregoing reasons, we vacate the portions of the order directing the fines, and we vacate that portion in its entirety. So all the fines go away, and then they know, but the Attorney General still has remedies. She has injunctive relief, so that she can bar Trump from doing business in the state, bar the sons from doing business in the state, and that's effective. All of that remains in place. So Trump got out of the fines. The bigger issue is that this underlying cause of action, where any business in New York State can be sued under this consumer protection statute, where no consumer claims harm, where no lender or insurer relied on the supposedly false appraisals. And by the way, in the real estate market, every appraisal is squishy. There's no absolute value for any property on an appraisal level. You look at comparables, you look at location. It's a whole cascade of judgment calls. You don't know what a property's actually worth until somebody shows up at closing with a check and pays you that dollar amount. And the next day, it's not worth that much anymore. It's only worth what a buyer is willing to pay. All these appraisers are squishy, and any property at any moment in time has multiple appraisers. My home, if I were to go to sell it today, I would have it appraised, and I would get a prospective sale price of the home. But for property tax purposes, my home appraisal is completely different. And this is true everywhere for everybody's home. The property tax appraisal is a fraction of the market appraisal. I don't know why it's done that way. I mean, thank God it is, or my property taxes would be insane. But this is normal. Different means of appraisal for different purposes are all different. And the banks, the lenders, and the insurers here, these are all multi-billion-dollar corporations who are engaged in sophisticated real estate transactions of this type every day of the year, all year long. The notion that they were fooled by something Trump did is ridiculous. It was like you going to the bank and you count out 10 $100 bills, ask them for a $1,000 cashier's check, and you're just hoping to fool them that really it's only 8 bills, but you're pretty sure they can't count past 8. The very notion is ridiculous. So more to shipwrecked crew's point that every business has to leave New York. You can't be a business in New York and operate under this kind of risk profile. It's absolutely insane. Thanks for watching this highlight segment of our full-length Law Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.